Today we're talking about what happens at your very first court date if you've been charged with a misdemeanor violation. Your first court date is also known as an arraignment. And in this video, we're not going to be focusing on civil arraignments, so like if you've been charged with a traffic ticket, or felony arraignments or initial appearances if you've been charged with a felony, but we're going to focus only on misdemeanors. So we have our stick figure Paul here, who has a lot of question marks and a lot of confusion, which is generally the case for much of his life. And although we're not going to be able to answer a lot of those kind of big existential questions for him, we can help him in this case. So Paul's been charged with a crime, and he has a question about what happens at his very first court date. He's never been to court before. He has people telling him different things. He sees a lot of bad information on the internet, and we're going to answer a lot of those questions in this video. What does Paul need to do at his very first court date? So, the arraignment. Here's what happens at an arraignment. As you can see here, I have three different parties lined out. These are really the three essential parties in any criminal case. This is the judge, this is the prosecutor or the state or the government, this is the defense. So if Paul's charged with a crime, Paul is going to be considered the defendant. And these are the three parties. So on the very first court date, an arraignment is not very substantive, meaning not a whole lot is going to happen at that initial setting. What the judge does is he brings in everybody into the courtroom, or you have to go into the courtroom, and the judge is going to call every single person who's not represented by an attorney up one by one, and he's going to arraign them. And so what that means is that the judge is going to tell that person what they've been charged with and what the maximum penalties are. So you can see here that I have the three different classifications of the misdemeanor offenses laid out. A class 1, which is the most serious, a class 2, and a class 3. And so let's dive in real quickly, and we'll tell you what the judge is going to tell you what the maximum penalty is for each one of those things. So for a class 1, these are for offenses like DUI, domestic violence, certain levels of assault. The very high end of misdemeanor offenses are all class 1. And the judge would tell you, now keep in mind, this is not what you're going to get, but constitutionally the judge has to tell you what you've been charged with, what the maximum penalty is for that charge. So for a class 1, the maximum penalty, the judge cannot give you more than this, or the government cannot give you more than this, is 6 months jail, fines of $2,500 plus surcharges, up to 5 years probation, and then the judge can impose some other additional penalties. But those are the big ones that you need to be worried about. They go down the lower level the misdemeanor is. So for a class 2, it's up to 4 months jail, up to 2 years probation, and up to $750 in fines and surcharges. Now surcharges can be pretty extreme. The lowest level is the class 3, and for that it's 30 days jail, 1 year probation, and fines of $500 plus surcharge. So that's what the judge would tell you. So practically what he does is he calls everybody up one by one. So he would say, you have been charged with DUI, you've been charged with criminal speeding, you've been charged with domestic violence, and then he would tell you what those options are, or what the maximum penalties are. Then he's going to get into your options. So at that time, you have certain options. You can either plead guilty right there, right then and then on the very first court date. You can plead guilty. Now, we never recommend that because the case needs a lot more work and a lot more development in order to determine what type of outcome is going to best suit you or be in your best interests. So it's almost never something we recommend to go into court and plead guilty at the very first setting or at the arraignment. So what the vast majority of people do, and almost every single one of our clients does, and we do this for them, is we plead not guilty. So we go into court, we tell the judge we're going to be pleading not guilty to all of the charges, and then this arraignment at that point in time is essentially going to be done. They're going to continue the case. You're going to have what's called a pre-trial conference in about 30 to 45 days or so, and then the case is going to develop from that point. Now, some people have some questions about, can I go in and talk to the judge? Can I, at my very first setting, can I get a reduction? Can I speak to the judge and tell him, hey, this is my first offense, can I please reduce it? Those types of questions. In most cases, the answer to that question is no, you can't, okay? And here's why. So as I mentioned earlier in the video, we have these three different parties. You have the judge, you have the prosecutor, and you have the defense. The judge is the neutral, supposed to be neutral, basically arbiter between these two sides. So if you go into court on your initial court date and you ask the judge to do something, legally the judge doesn't have the authority to do that, to make reductions or to dismiss the case or any of those things, because the charge, the original charge that Paul was charged with, is brought by the prosecutor. So the police officer turned in the charge to the prosecutor's office. The prosecutor is the one who's formally moving forward with the charges. And so they are the only ones with the legal power, the legal authority. In most cases, there are some exceptions or ways around that. But in most cases, the prosecutor is the only person who can actually dismiss the case or offer you a plea deal or offer you a reduction. So if you're watching this video and you have an intention of going in and asking the judge to please reduce this down or give me a better deal or dismiss my case altogether, it's almost not going to happen. It's virtually impossible that happens at your initial court date. What you're going to want to do is come back, meet with the prosecutor at the pre-trial conference, and you can begin discussing that with them at that time. But at this first setting, and we're only focused on the arraignment at this point, the judge just simply doesn't have the authority to do that. In some courts, depending on where Paul's case is out of, you may meet with the prosecutor at the arraignment. In most courts, you don't. Sometimes you'll meet with the prosecuting or the prosecutor's assistant. They may offer you a plea deal at that first setting. If it's something that ultimately sounds good to you, you have the ability to take it. But like I said earlier, in most cases, we don't recommend that because you do want to get police reports, you want to get officers' notes, you want to present your mitigation, you want to begin doing interviews with all of the witnesses. There's a lot that goes into building up your defense, and there's not enough time to get that accomplished by the arraignment. So in the vast majority of cases, nothing really substantive happens here. You enter a plea of not guilty. The case gets bumped out. It gets rescheduled for a pre-trial conference in about 30 days or so. If you have an attorney, we do all of this for you, so you don't even have to go to court on your first setting for arraignments. Some courts require physical appearance, some courts don't, most courts don't, as long as you have an attorney. When we contact the court, we enter a plea for you. We don't need to meet with the judge and have them explain all of this to us. So we just say not guilty, then they give us the new court date. If you cannot afford an attorney, if you don't have a lawyer, you don't want to contact our firm to seek help or anything like that, and they're asking for jail in this case, in your case, so if Paul's charged with a second offense DUI or something like that, or a first offense DUI and there's mandatory jail, and he doesn't want to hire a private attorney, he can talk with the judge, with the court at that time, and the court may appoint him an attorney. So they'll review his finances, they'll decide whether or not the government's going to pay for an attorney, and then he would be assigned a public defender. Again, the case would not be resolved here. They would enter a plea of not guilty, assign him the public defender, and then his case is going to be reset in about 30 to 45 days or so for the pre-trial conference. So that's really how it works, okay? It's nothing to be too nervous about if you do plan on going on your own. In most cases, it's a pretty quick proceeding once you are in front of the court. You may be in the courtroom for a very long time because the judge has to get through everybody who's there. But once you're in front of the judge, it's usually just a quick reading of the charges, a quick explanation of what the maximum penalties are, and then the judge really wants to know, what do you want to do? Do you want to plead guilty? Do you want to plead not guilty? Are you going to be hiring an attorney? Do you want a court-appointed attorney? Do you want to just immediately set your case for a trial? You have certain options at that point, but in the vast majority of cases, you can't go wrong by entering a plea of not guilty. Now, some people are concerned. They say, well, what if I am guilty? What if I did do it? This is something that I did. I just want to resolve it and basically beg for mercy at that point, or beg for forgiveness. It's perfectly normal. It's perfectly okay to plead not guilty. You have to do that. If you want to change your plea down the road at the next setting or the following setting, or in 2 months from now after you've been able to negotiate with the prosecutor and you have a better understanding of what the penalties are going to be, you can change your plea back to guilty at that later time. But in order to get all of that processed, to meet with those prosecutors and all of those things, you have to plead not guilty at the beginning. So I hope that this helps. I hope, of course, that you don't find yourself in this position, but if you do, that's how an arraignment works. If you'd like to speak more about how the rest of the process works, or if you'd like us to handle the arraignment for you, give our office a call. We offer free case evaluations, affordable payment plans, and we look forward to helping you make sure you get through this with as little harm done to your reputation and your future. Thanks for watching.